Good afternoon, everyone. My name is Carol Montoya. I'm the Executive Director of WIND, and I want to thank everybody for joining us today for what is going on in the other room, what you need to know and plan for in first-party mediation cases. This webinar offers a free member benefit. It's also a good way for non-members to get to know us and see what we have to offer the industry. If you're not a member, we encourage you to join. I will put the link in the chat. We also encourage everyone to join us at the WIN 2025 conference, which is scheduled for January 26th to 29th at the Hyatt Regency in Dallas. I will put that link in the chat as well. A few housekeeping items before we begin. In order to qualify for continuing education credits, you must be registered for the program, meaning today's link was not forwarded to you by someone else, and you must be accessing the webinar via that Zoom link and not phone only. If you have any questions for the speakers during the program, please use the Q&A feature. If the questions are placed in the chat, I will chat you back and ask you to type it into the Q&A. If you're having any technical difficulties or have any other questions, please use the chat and I'll be monitoring that. We'll conduct 3 polls during the session. They will each be announced verbally and on the screen, and you have to complete those polls in order to prove your participation for continuing education credit. So that does mean if you're dialing in only, we can't record your participation. About a week or 2 after the program, you'll receive a certificate of attendance from our accreditation partner, the CEU Institute. If they don't have your state registration numbers on file or receive them from us, they may contact you for that information before they send your certificate. No later than tomorrow, all registrants will receive a link to the recording of the program and a copy of the PowerPoint. So a quick introduction of our panel. Unfortunately, Kelly Overstreet Johnson is not able to make today's presentation. She had a scheduled arbitration that has unexpectedly been extended today. So with us today, we have Patrick Russell. Patrick's a seasoned mediator at Salmon and Dulberg dispute resolution. He's certified as a Florida Supreme Court Civil Circuit mediator and brings extensive experience in insurance law, personal injury claims, and business disputes. We also have Ido Alexander, who's an experienced mediator at Salmon and Dulberg as well. He's recognized as a Supreme Court Certified Circuit Civil Mediator. He specializes in mediating first-party property claims, personal injury cases, complex business disputes, and utilizes his proficiency in new technologies to conduct virtual mediations across Florida. I will turn it over to you, gentlemen. Thank you for being here today.
Thank you very much, Carol. We very much appreciate it. And as you noted, Kelly is not with us, but she will be missed on this presentation. But without further ado, why don't we go ahead, and since you've introduced us, why don't we go to the next slide. So first and foremost, thank you very much for the opportunity. I think where we'd like to start with is some statistics, because I think that is a good place to guide our conversation as we move forward into what's happening in the other room. Patrick, you want to share with us what's on the left side, the circuit civil dispositions. What are we looking at there?
Well, for sure. And again, I appreciate the opportunity to go ahead and do this again, and hopefully we can bring some new insights into this very important topic. And previously, when we did this at the last WIN conference, this was actually our last slide. But when thinking about it, I thought actually maybe it should be our first slide, because it really tells a story of why we are here. Why do we end up in mediation, and why is it important? And these slides are from the Florida Office of the State Courts Administrator, so it's direct from the court system itself. And it tells a really, really important tale, in that the fact that if you look at the pie chart there, only 1.4% of all civil cases actually go through and are resolved by a trial, whether it's jury or a bench trial. That's 1.4. And I thought that was super significant, given that many folks, whether it's clients or lawyers, they say, hey, we want our trial. That's what we want. We want a trial. And flipping that around, you think, well, statistically, you're not going to get one. Really? Most people don't. In fact, the vast majority, as you can see, it's like about 75% are dismissed. But why are they dismissed? Well, some are obviously because the claims are faulty, need to be refiled, or they're just not really good. But the other option is that the vast majority, I would believe, are settled, right? at least 75% of them. So that's why I thought it was an important slide to lead off on, because that's really what we're doing at mediation. And we really should think about, if the vast majority of cases are in fact settled, then why don't we really try to work really hard setting up our cases for success during mediation and do that sooner rather than later?
So, Patrick, when we look at the graph on the right side, which is cases disposed pursuant to a mediated settlement, and there's a statistic right there that says 5.4%. Do you think, by any chance, that the other 94%, it's a misstatement, or in other words, that number is mischaracterizing the nature of the disposition? What I'm getting at is mediation, in many respects, a lot of times, it serves as a stepping stone towards a potential resolution down the line.
Correct. That's one way to look at it. So maybe it didn't actually resolve during mediation. But I also think that that statistic is very, very, how would I put it? It's off base, because one thing, I mean, and I've spoken to many, many colleagues and mediators about this, and not one of them would agree that only 5.4% of the cases that they mediate are settled. There's not anybody that I met that has that as their reference point. And really what we all think that's going on, and we actually discussed this at the ADR section of the Florida Bar at one point, is what we really think that's going on is that there's an underreporting by mediators, by lawyers, and even by the court system itself as to the case being resolved at mediation. There's not really a real formal requirement that it be reported as settled. I mean, we do that as a matter of practice at our firm, but not everybody follows that. So I think it's a vast underreporting of the success at mediation. What do you?
I would even venture to say that there's limitations to the tracking itself. So the reporting itself is extracting data, and I would suggest that the data is probably underreporting it by virtue of how they're keeping track of it and what reports they're pulling out from it. So with that, is there anything else that we think of, folks that are listening, that you can think of as to why that 94% is just so high for other dispositions and settlements are just at 5.4%? Any suggestions? No? So
There's one Q&A question talking
There
about
is.
the pie chart from Dan LeBeau. I hope I pronounced that correctly. And the question was, does the pie chart differentiate between pre-suit DFS mediation versus mediation once litigation has commenced? And I think the answer is that this is all civil cases, because this is from the court system. And so it appears that these statistics are related only to the court after a lawsuit has been filed. So we don't know what DFS is actually doing or their results.
Right. And DFS keeps the information to themselves. I have had some conversations with DFS. Nothing of this that I'm about to say is official, so please don't take this to the bank. But what I have been told is that they're working on a reporting that would allow folks to see sort of what the big picture is as to DFS mediations. But I suspect that that's just way down the line. But why don't we go ahead and try to move on to what's happening in the rooms? Because I think that that's telling as to the mediation process, how it's conducted, and how to maximize it. So why don't we go ahead and move to the next slide, please? And we do have a poll.
All right, so there's a poll on the screen, and while that's up and you pass that quiz, hopefully, we're going to talk about what's going on in the insured's caucus room, otherwise known as the policyholder. Now, a couple points on that. What's unique about this is that as mediators, and I often tell those participants at my mediation, is that I have, and Ito as well, we have the unique ability and bird's eye view to see both rooms. We can't necessarily tell each room what's going on in the other, right? But we have this interesting perspective of seeing how people, struggle or succeed in their respective rooms. And there's often different issues going on in those rooms. And that's kind of why we're doing it and breaking it down according to the caucus rooms. And I was thinking of kind of like an example of how I would analyze this problem. And I was thinking the other day, think about it as a diagnosis, really. Like this is your mediation, and how do we diagnose the problem? And think like mechanics or doctors do, right? So auto mechanics know that an engine, all right, needs three things. It needs air, fuel and gas, and fire, electricity. If any one of those three is missing, the engine doesn't turn over. So they start looking for those three causes. I think the same kind of analysis can be done for mediation, where you look for what is needed for a resolution in a particular case. Is it money only? Is it time? Is it respect? Is it what is it? And everyone is different depending on the personalities and the problem that's present for each party. So this is where I guess when we start going into these rooms, keep that kind of mindset of trying to be kind of a mechanic for mediation. How do we kind of figure out what's going on in that other room and give them what they need? That's kind of, I think, what kind of an overriding principle today, our mantra is give them what they need.
But each party needs different things, right? Because when we're dealing with, and now we're in the insured's room, things can get very interesting, right? What exactly are you asking for? Oftentimes, do you find yourself that you're asking, what exactly are you demanding? How much are you demanding?
And how about this? Oftentimes, and these are like, we'll throw in certain things that we obviously observe that either are good, bad, or indifferent, but they're just observations. I often think that when we come to opening demands, what do you do? In my mind, a good practice to follow would be to at least reflect the prior negotiations, right? If there are any. I find that when parties ignore prior negotiations and go off the tracks and kind of restart them, and usually, let's just say from the plaintiff's perspective, they start higher than where they left off last. What does that do, Ito, if you've seen that in your in the room?
At least I call it the time waste, 30 to 45 minutes just to put the train, the engine back on tracks, right? Because now you're basically spending the time to try to figure out, can we start where we were last at? And I think that there's some element in the opening demand that's also a calibration of how do we move this conversation forward, right? Because if we can't articulate a demand that is grounded in reality, if we can't articulate a demand that is driving the conversation forward, and we're sticking to the typically what you'll see in these types of mediation is what the adjuster's report, right? The public adjuster's report. Plus, if you're statutory change, you're dealing with the attorney's fees. But yeah, that is the opening demand. But are you really driving the conversation forward?
And when you go off the tracks and reset it without a particular reason, right? I would understand if something significant happened in the case where something new was learned, whatever it may be. But if you're exactly in the same point that you left off before, and the only thing that passed is 10 days, and then all of a sudden the demand has doubled, that's a major problem. And yes, like Ito says, that will take, I would say even longer. I've seen it take an hour just to have it fixed. To get back to having a conversation, because now the other side is wondering what's going on. Explain.
Well, it's not only it's that, but you're also, the analogy I use is, and I like to use this in my mediations, is the borrowing from cosmology, I guess, and that is two different universes, two different galaxies, and two different solar systems. Well, with an opening demand that is not only not driving the conversation forward, but rather taking 5 steps back. In a way, you're signaling to the other party, you're not only exiting the galaxy, you're going to a different galaxy, into a different universe, and changing the conversation altogether. So that's why I like to say, oftentimes it's going to lead to at least, I think I'll share with everybody here, I've once or twice or 3 times tried to time it, and the consensus is after 3 data points is it's about a 30 to 40 minute extra add-on to drive the conversation back to where we were. Because I think that in that opening demand, there's also what's going on in the insured's room. And I think that, you see that in the insulting offer, right? you see that with the classic, how should we say it, recitation of the facts and the legal position. And while that's very important, I think I think you need to sort of condense, bring everything into what Patrick was talking about. But this is a dispute about money at the end of the day, is it not, Patrick?
Yeah, for the most part in these particular cases, and I think to your point, Ido, offers should be both reasoned and somehow supported. I don't think there can be anything worse than just throwing an arbitrary number out there and not explaining it and just saying, I want that because. That's fine. And you may be able to do that also for a jury, but remember, mediation is different. Here we're trying to get the other side to agree with you, and they need some sort of data points to figure out how to support and justify that demand. And if you're not willing to give that information, then it's very hard for the other side to agree.
Not only that, a lot of times what you end up having is the form substance. What you're referring to is the substance. What's underlying this claim, and how can we attach the substance to the ultimate number? And oftentimes, what you see is the form of what happened in the case, the procedural history, and what had taken place prior to suit, from the inception of the claim through the filing of the suit through the present time. That ends up being sort of the topic of conversation, when in fact we're here to talk about a number that's associated with an actual basis to it that can lead us to a conversation that ultimately needs to hopefully end with a resolution. Are we not? But I think part of what's happening in the room, and this is something that we touched on right here, and that is outcomes, trial outcomes, reality check. Do you often find yourself having a conversation of where we are in the case and what's the next steps?
Yeah, and I'll give you a recent war story on this. One of my recent mediations, the policyholder was making a claim, and their reliance was upon an email, okay, in which a roofer said, I needed X amount of money, or he would like, actually, I think the word was used, I would like to have X amount of dollars to replace the roof. All right. There was no written invoice. There were no measurements. There was no estimate. There wasn't anything other than an email. No breakdown as to what was for materials, what was for labor, anything, just a number. Well, that wasn't real helpful, as you can imagine, because the insurance company kind of operates in a different realm. And sometimes you have to kind of meet them where they are to get them to move to your side. And that kind of a monkey wrench wasn't real helpful. And I'm not sure if you had that kind of experience, but you want to be able to back up some of this stuff as best as you can, because what are you going to do with it? It's like, I want this money because I said so. Well,
you're going to have to prove it, right?
Yeah.
And that goes to the conversation that oftentimes what I find is that there's no conversation that's taking place. If this is, for example, even in a trial setting, in a mediated civil mediated case, meaning a case was filed, the mediation is taking place, or in a DFS forum style mediation, meaning pre-suit mediation. Oftentimes, at least from my perspective, and Patrick, please chime in on this, and that is, you oftentimes don't see folks talking about what is going to happen next. How do we articulate what's going to happen next? And at the same time, the insured many times is being led by their, in the beginning of mediation, I like to say the insured is the decider, the adjuster that's accompanying, if it's a pre-suit mediation, or if the attorney, for that matter, is the advisor. Okay. But in that setting, the advisor, their role is to ultimately try to articulate, what does the world look like if we leave here without a successful mediation? What does the world look like? What's the alternative to this? It's the classic, getting to yes. For those of you who have not read the book, please read it. That's a must. Getting to yes, famous book. I forget, Uri, that's the name of the author. But what is your BATNA? What is the best alternative to a negotiated settlement? Oftentimes, I find that as the mediator, we're trying to engage in a conversation that at least try to outline where is it that the parties are situated in terms of leverage, where they are, and what is the alternatives to the mediation and leaving without a settlement. But I think that it goes to the whole heart of it, which is the insured's participation, right? The insured's participation in the mediation, again, as I said, advisor, decider. The decider needs to be part of this. This is not just a party that two people that are talking, mediator and advisor, while the decider just sits idly by.
I agree. Oftentimes you will see a policyholder that is a passenger. They're just along for the ride. And oftentimes you don't know, right? And so I always do try to ask these type of questions to make sure, just like you were saying, Ito, what happens after this? Is there a proposal for settlement? Often there is. What does that little device mean in real world, and how is that calculated? And I don't get into that. I will ask, and then usually counsel will jump in and explain it. Hopefully they've had that conversation before, right? But I sometimes I like to add, proposal for settlement could be an insult to injury. Imagine that you do recover, but it just isn't enough. Then you have to end up paying legal fees to the other side. And that's kind of a bad day, right? And that sometimes set off light bulbs like, oh, wow, never thought about that. Well, you should, right? And we have to go through those scenarios because at the end of the day, mediation, the way I often describe it, not only is it a negotiation, it's not a place to prove a point. That's court. This is a place to make a deal, but you also have to do risk assessment and analyze, okay, what are my chances of success? How do I get there? And if you just rely upon your full demand that you want and you make no concessions, well, that's your best day in court. I don't think the other side is going to give you your best day in court, right? And vice versa. So really you're trying to figure out for everybody, what is your tolerance for risk and what is that number that you're willing to either win or lose?
And in doing so, I think it goes to your analogy earlier, which is the auto mechanic analogy that you used. If you go to your auto mechanic, you can come in and say, hey, I'd like this car fixed, not ask questions, but then you may end up being sold a bag of things that didn't happen in your car and your repair. Or you could be, as the passenger, you said the silent passenger that's on the train that's not interacting. The client, the insured, he's ultimately there to ask the questions. It's up to the advisor, quote unquote, attorney or public adjuster to guide them along, ask the right questions that would allow them, with the help of the mediator, to do the analysis that we're talking about, right? The cost benefit, what happens in as next steps, and try to articulate to themselves, what is the power structure as we're negotiating here, and what is the likelihood of success at the end of the day? Because if we can't evaluate it, then, well, what happens if we can't evaluate it?
Yeah.
Patrick?
At the end of the day, the way I like to look at it is that as mediators, our prime directive really is to, one, ensure that we have a neutral process, so not advocates for either side, but also to ensure that the parties are exercising self-determination, making their own choices, and making informed choices, not guesses or just kind of flipping a coin there. So that's why, and so lawyers shouldn't take it personally if sometimes we ask these questions, just so you know, is that we need to make sure that people know what's going on, right? They know their options and they choose. And it could be a good choice, a bad choice, but the point is they make a choice and they know what they're doing. That's really our prime directive. Obviously, we want to get a resolution. That's really, we'd like to see as mediators, people resolve their differences. But at the end of the day, at least getting them to a point where they can make an informed decision. And all the cards are on the table and people decide, yes, this works for me, or it doesn't.
Well, the informed decisions the informed decision is critical, and that can become a challenge when you have the direction to pay AOB, right? Let's talk about a little bit about that, Patrick. The AOB. Obviously, there's been some statutory change here in Florida in recent times, not some, a major statutory change. So it's less of an issue, but now you have more of the directions to pay, and third parties that are essentially sitting there. That is the providers of remediation services, mold inspection, and the rest of the other professionals that may not be sitting in the room. And then you have a challenge, don't you, as part of the informed decision process or informed choice in analysis?
Yeah, well, another war story. So a recent mediation had this particular issue pop up where there was both an AOB and a direction to pay. However, they weren't aware of the details. All right. And weren't able to connect with those parties to know if they were paid, whether they would negotiate. And that put a real hurdle for the process of trying to resolve, because the insurance company said, well, it doesn't matter to us, right? We're settling this. We're not going to also pay those folks. It's going to have to come out of your share. And if you don't know what that outcome might be with the AOB and the directions to pay, because your client is theoretically on the hook for some of those things, that's a problem. So you need to also think ahead and get that all lined up, get your I's dotted and your T's crossed, right? And this is also an important element.
It very much is. So there's been in recent times some major statutory changes in Florida. One is the no AOBs, no assignment for the benefit. And then the other one is the elimination of an entitlement to the insured's legal fees. Let's talk a little bit about how that, what does the world look like from the pre-statutory change, and what does the world look like post-statutory change? Because I think that on both, it has impacted both mediations and what's happening there. And I will bring in a comment that was made by one of our participants here that talks about that he's done hundreds and hundreds of pre-suit mediations and never had a mediation. Never had a mediation fail and the insured not obtain better settlement through other means, appraisal, litigation, or subsequent negotiated settlement. Not once. Well, that was the comment that was made. Now, the question comes down to how does the AOB, the elimination of AOBs, you think, and the change in legal fees, how do you think that has impacted that kind of comment or conversation of pre-suit mediation, Patrick?
Well, one thing is if this is a topic of interest to you, you should tune in Dallas in January, because Ido and I will be doing this specific discussion there at WIN 2025 on how the world has changed. The new formula, I think, is what we had titled our presentation for first party claims. Would be, I guess, specific to Florida, right? With the statutory changes of no legal fees, which just changed 100 years of jurisprudence in the state of Florida. Well, a couple things. One, I think what you're seeing is that now you're getting issues where lawyers are going to have to obviously take this on a contingency basis for some sort of a fee, which obviously pits lawyer versus client at the end of the day sometimes when the money is tight, right? The other component that's of a concern is that assuming that you need $100 to repair your door, and at mediation you get 75 and your lawyer gets 20% of that, and then you're left with maybe half to be able to pay for your door. Well, that's a real problem, right? And that's something that may be forthcoming soon with all these storms that we've had over our summer. We shall see how that shakes out. But that is obviously a concern, because if those funds are going to pay for legal fees now, then there's not going to be made to pay for repairs. So lawyers are
Well,
now going to have to do this smarter. They're going to have to file their own proposals for settlement and treat these kind of like very efficiently like personal injury cases.
well, I mean, and that I think impacts certainly the pre-suit mediations as opposed to in a major way, because now you got to figure that your alternative adds an extra 20, 30, 40% add-on in a potential alternative. And then there's what I've seen oftentimes that's happening in the insurance room is that there's a sense of I may be doing better in a litigation, but now that you have this additional layer of cost, and then I'll add on top of that, there's a sense of, well, if I go and pursue this next step, the assumption is I'll get the entire door. Well, it may be that you'll get half a door plus 20% or 30% of the fees. So how does that compare to where we are in the mediation? That's not to say that the next step should not be pursued, by all means. But I think that there needs to be an evaluation. And what I oftentimes see in the insurance room, at least, is that there's at times it seems as though there's no analysis being made as to what happens next, right? What is that evaluation? And it goes to what we're talking about in Dallas in January. The analysis is just not there as part of it.
In one of my mediations last week, this discussion was ongoing. So unlike your observation, it was going on, and it was painful for the policyholder, because they were literally writing on a piece of paper, okay, I need X to fix Y.
Well, they're working it backwards effectively.
And they're paying me Z.
Mm-hmm.
And, oh, by the way, counselor, how much do I owe you? Okay, let me subtract that. And then you see a lot of head scratching. How am I going to pay for this? And a lot of frustration. As mediators and as lawyers, that's something that we're going to have to deal with. And that's not going to be an easy road.
Not at all. Now, there's the direction to pay, and I want to touch on the direction to pay, because now with the evolution of the statute, now that there's no AOBs, you oftentimes find insureds that have signed the direction to pay to these third parties, remediators, mold inspectors, mold remediation, and so forth. And that bill is sort of that silent cost that nobody really is not sure how can that be resolved. Oftentimes I hear, well, we could try to resolve it and negotiate with them. Well, or a call is being made, right? Have you had, let me pause for a sec. Let me go make a call and find out whether I can negotiate with the remediator for a lesser amount. And that becomes a challenge, the directions to pay, because they're almost like a silent participant. They're there, but they're not there.
Yeah, I would suggest those calls need to be done before mediation. If the light bulb goes on during the mediation proceeding, oh, I should really reach out to them. Chances are you're not going to get a hold of them. And then what do you do? Right. And so if you want to set yourself up for success, which is again what we're trying to do today by describing, some good best practices. Here's one area. Get these items lined up so and the client will ultimately want to know this as well. And no client likes surprises. So if this is not addressed and then it's addressed in the back end, that could be a painful moment.
Well, and it goes to, again, what we talked about, which is risk assessment cannot be performed absent the information that's there, right? And how can you make an informed choice if you don't have the information? Well, it's all about the preparation. And I think that leads us to the next step, which is, let's talk about what's happening in the other room. So why don't we go to the next slide?
Well, before we do that, one final war story point on that last issue,
Please.
Conflict of attorney's fees, and I think it's really important. I witnessed this in one of my mediations where it was a lawyer had his client in his conference room. Okay. And the lawyer was sitting closer to the camera and the client was behind the lawyer. That was the setup. All right. And at one point there was an offer that was being made. And I asked, okay, so how do you feel about this offer? Is this something you're willing to do? Do you want to resolve this case for this particular number? The lawyer was adamantly shaking his head no. The client behind him, unknown to him, was shaking his head up and down yes. That's kind of a problem, right? And they're so who's in control of the case, right? So it is
Well,
something that's going to be coming. It's going to be this natural conflict when it comes to also legal fees and the client, where they're pitted against each other because there's only a limited pot, and now you got to divide it.
and I think that goes to the equation I talked about, advisor versus decider. The ultimate decision maker needs to be there and be participating, and actually the advisor, while they have their fees, they need to remember that they are the advisor at the end of the day, right? That they're not there to
As
take.
a question for us in the Q&A of discussing strategies when mediating with an entity that came unprepared, not informed of the facts or history of the claim, and has been given a lowball authority dollar offer.
Ooh.
What do you think about that?
I think another 30 minutes is now spent on trying to develop the issues and exactly go item by item, Mark. That's just a gentleman that has asked this question. It's a great question. Yeah, you end up spending a lot of time trying to guide as a mediator. That's part of your job, right? It's to guide the parties to try to vet the issue. And now it's your job to try to work through it and try to articulate everything that you just mentioned in the question, so that you can make, or at least get the parties and at least one side, that room, to be in a position where they can make an informed choice ultimately. And in this case, it is the advisor's ability to provide that advice for the party, for the decider, to make the informed choice. So now you're spending a lot of time. And sometimes it may require, I've had it about a month ago where I literally suggested, hey, maybe it's worth it to pick up the phone and have the conversation with the other adjuster to just fill yourself in and just get up to speed on everything, because he just had a lot of questions. And you know what? Information is power. Information is power. And if it could drive the conversation forward, there is no reason why folks can't pick up the phone and say, have a 5-minute or less conversation. And that 5 minutes is an investment towards the parties truly articulating what they need, what is their bottom line, and how can they move the conversation forward. But
My take on that, Mark, is two things. And it echoes what Ito said in terms of, as unfortunate as it is, if you're on the other side of that, you really have no choice but to try to educate the other side, give them the information that they may not be aware of. And the way I like to put it is, share information with the other side so they can see the case more like you. Right. And that's what you really need to do. And you would hope that the other side was prepared, but if they're not, then this is what, if you want to have a successful and meaningful mediation, you're going to have to be prepared to educate the other side then on some of these nuances. There's limited things that we can do as mediators because, one, we are not entangled in this case and we just came in, right? We do not have all these facts. There's only limited things we can do. We can ask some of these questions, but we don't necessarily have the answers. That's going to come from the parties.
Information. And I think that there's a question here that was asked that talks about surprises and the trying to eliminate the surprise out-of-pocket expense to the client. And a comment about how, I know it's generalizing. I think that that's a generalization in that question, that public adjusters are also ignoring the balances owed to contractors on work performed. I think that goes to the heart of what we're talking about, information and trying to obtain as much information as possible, and trying to, for us as the mediator, to ask these questions of the party and trying to understand, is everybody on the same page in trying to ultimately reach a resolution, that there's no surprises down the line for the insured, because that's the worst part, right? Is entering into a resolution whereby all of a sudden there's going to be a surprise to the insured. And we want to make sure that doesn't come to that.
I mean, let's be honest, in the policyholder's room, the various specialists that are available on that side, whether it's roofers, contractors, plumbers, electricians, whatever it is, public adjusters, you guys are a team. You are the experts when it comes to what it's going to take to fix and how much it's going to cost. And if you're disjointed or not participating or helping each other, it makes the job of the lawyer in that room and also for the client much harder to recover and to ultimately pay you. So I always say, help them to help you, right? And so that would be my best advice. You got to circle back and circle the wagons and work as a team to make sure that you have the best presentation possible so that you can get that good settlement and then everybody can get to work.
So now, what is happening in the other room, the insurer's room? Let's talk about that.
So yes, the insurance company room. So we need our next slide.
Next slide. I think we went through. There's some question as to the last poll. So here it is. It's right there. Okay. So what's happening in the insurance room? The classic, I want $200,000, and that is the demand that was made. And the insurer is doing what again? What happens there as a response, Patrick?
The insurance company, I like to call this a punch in the face. It's like somebody just turned around and smacked you, and you're like, what? Right? What just happened? Where did we get to from here to here? Why are we here? So it's the same line, the reverse of what we were talking about in terms of making the reason demand. If you make this unsupported and or arbitrary demand, or you change the terms of the negotiations where all of a sudden it just goes off the train, off the tracks, that is a punch in the face for the adjusters in the other room. This is what they do all day long, by the way, right? Adjusters are in, and the mediation specialists, they do this hundreds, if not thousands of times. So
multiple times a day.
They are prepared, and there's certain expectations and traditions, right? And they all talk to each other. They all have expectations. And so when this happens, it throws the process off the rails. And I think that for the most part, the adjusters, some of the reactions I see, and I don't know if you see anything different, is they don't think that you're being serious. They don't think that you came prepared, which you don't want the other side to think that ever. And then the converse of this, which I think is also very important, and this is another war story, when I see a reasoned offer being made, right, that's supported and it has some sort of factual basis behind it and documentation, the demeanor and the enthusiasm and the interest of the adjuster in the other room noticeably goes up. You can literally see like an energy level rise up. Versus the other where they're just kind of there, or you get them mad or confused, which you don't want the other side to be.
Well, we're all creatures of habit, right? We're all we all have expectations, and if you shock them with something that they did not expect, then there's a negative reaction to that, right? They're coming into an initial conversation with the insured with the idea of, here's what the demand is going to be. And if you can meet and exceed that in the initial demand, then you could reframe the conversation. I often find that if you have a person, the insurance representative, who at least comes to expect X and gets X or even less than X on the initial demand, or maybe that next step, that often drives the conversation in a very positive manner, right? Because there's a surprise. There's oh, wait, maybe they did. Maybe there's a recalibration in the other side. Maybe there's an objective way of looking at this claim that the other side is certainly showing objectivity on with their initial demand, and maybe that's just a signal to us we need to come in and also meet that. We also need to try to drive the conversation forward as well.
And think about it in terms of between the parties. The insurance company has presumably already had at least one inspection, if not two. They've gone out there and done their Xactimate, right? And they've measured everything and they've calculated. And obviously, we all can disagree in terms of what's in that report, that Xactimate report, whether it's justified, whether the numbers make sense for the location and the change in pricing and labor and all that stuff. We can all disagree about that. But at least they came prepared with that, right? And everybody knows that they're going to come in with that. It would be helpful to counter that, right? And not to go off the tracks with a number that doesn't even, it's not supported by your own documentation. That causes a cognitive disconnect. Like, okay, why are we here now when your own papers say Y and you're asking for X? I don't understand. It doesn't compute.
It doesn't drive the conversation forward because, so here's a question for you. Do you find that the timing of the mediation is impacted, or the timing of when the mediation is taking place is impacted by where we are procedurally?
For sure. This is kind of a, how would I call it? A pet project of mine, the timing of mediation. It would be helpful to have mediations when we know that both parties are ready to mediate. They've did what they need to do to get to a certain position to be able to conduct some sort of an analysis for settlement purposes, which is different than trial purposes, right? For trial, you are going to win. Mediation, you're trying to get a deal. But if there's some important event, and I'll just pick one that's just completely random, right? Motions for summary judgment. If that's pending, and you know that a particular insurance carrier will not offer anything other than a very, very nominal amount at mediation, regardless of what you bring, say, or do that day, while that motion for summary judgment is pending, would it not be more helpful to have a mediation after that? Because unless, of course, you're happy with an impasse or accepting a very nominal amount, which also is an option.
But Patrick, there's the uniform trial order that says that we have to mediate.
Sure. But oftentimes, if you really get into the weeds of that, there still is time to mediate. One, doesn't have to be when chosen, or two, there's absolutely nothing, and then correct me if I'm wrong out there, that prevents a lawyer from filing a motion to change the date of the mediation so that it is more meaningful and effective for the parties given this important event that is on the court docket. And we would prefer to mediate afterwards because we'll be in a better position to negotiate. I'm not sure there's too many judges out there that would say no to that when both sides agree.
Absolutely. Right. Because at the end of the day, we're here to have a substantive conversation, not a perfunctory for the form, let's check the box conversation. And I think that that's a lot of frustration is always exhibited by insureds, the insured and their counsel in observing that about the insurance is that it seems as though there's a want to follow the uniform trial order by the book rather than try to make the mediation more meaningful by observing that if there is an MSJ, motion for summary judgment, let's wait, or let's conduct the motion for summary judgment hearing, and only then conduct the mediation to generate a fruitful, engaged conversation, because we already know what the outcome is at that point.
And not all of them fall in the line that I'm speaking of. A lot of them do, right? Where the other side is not willing to negotiate at all, unless it's a very nominal amount, which is their prerogative. Can't necessarily say that's bad faith because you don't have to settle a case, right? But maybe there are instances in where the parties are willing to do a risk analysis and say, you know what, to avoid either a really bad outcome for one or both of us, well, usually it should be one, we're going to go ahead and settle it. But if you know already the other side's coming with a number you're not going to accept, then you might as well move the mediation, in my mind. I just don't understand doing the same thing over and over again and expecting a different result. It's doesn't make sense to me.
Well, it also goes not just the MSJ. The discovery plays a major role there, right? Where you're going into a mediation with partial information, and then it does happen, at least I'd say several times a week when I mediate, well, I find that not only is discovery not over or not even halfway complete, it's that we're engaged actually, and obviously mediation is all about exchange of information, but effectively, I've found that sometimes that mediation turns into a mode of discovery, an exchange of information, whereby de facto the parties are doing what they were supposed to do, and they're doing it as part of the mediation, and albeit it drives the conversation forward in a positive manner, right? Especially from the insurance's perspective, when we're arguing about a certain piece of critical information in their puzzle piece, because for them it's about oftentimes dotting the I's, crossing the T's, because at the end of the day for them it's all about risk mitigation. They're big corporations. They need to sort of check boxes and fill in missing gaps and missing pieces of information so they could ultimately, I guess, write a report, justify the amount, get approval for an amount. And I think it's critical that if we are to sit down and mediate, from a timing perspective, that at least discovery is complete. Exchange of the information that's relevant for the puzzle to be completed, or mostly be completed, is there. It's more, makes the mediation much more efficient for everybody. And look, in the insurance room, a lot of times you engage in a conversation. I found myself several times in recent times saying, wait, so this is the piece of information that's missing, that if you got this piece, is this what's going to make a difference for you? And the answer is in the affirmative. Now, they'll never say, yes, it's 100%, then we'll just pay up. But at the very minimum, you could tell that that piece of information could be critical for them to assess the case in a different light than they previously did, and drive the conversation forward in a positive manner, right, towards a resolution of some kind.
That is one of the main mantras of my mediation, is trying to promote the parties to exchange information, because that's how they can make informed decisions, know their options. And even if there isn't going to be a resolution on a particular day, I will ask each side, is there anything I can get that you need from the other side, whether it's some sort of documentation, discovery requests, you need depot dates, anything that will help move this case along so you can further evaluate it while we're all together. And I think the lawyers are appreciative of that, because it does help advance the case while they're together. And they start talking about what I consider a really big part of what mediation is problem solving, right? So instead of fighting, you're now working together to try to find a solution. And that's the essence of really what mediation is to find a solution to the common problem that brought you together.
100%. You often see in the pre-suit mediations, you see that the information becomes even more of a player in play, because from the insurance perspective, the insurance company, again, they're trying to make sure that they could justify. And, we have it on the slide here. It says, give me a reason to pay, right? It's basically them trying to support the number that they are ultimately being requested to provide by the insured, right? The insured demands $50,000. Well, it's up to the insurance representative, the mediation adjuster, mediation rep, or the mediation adjuster for the insurance company, whoever it may be that represents that company, need to provide him with a basis, something to give him a reason with basis of information. So then what do? They seek that higher authority, the classic, the call. And I think that on the call, it says here, the adjuster authority and the call that's being made. I think that there's, I oftentimes feel that that's something that you need to build towards in the mediation, and try to set it up in such a way that the parties, ultimately the insurance company is willing to make that call. And if they can't make the call, there's not enough information that's there.
Yeah. And
that's not been given.
I mean, the way to really look at it in terms of give me a reason to pay is that, back in the day when I've worked on both sides, but back in the day on the defense side, I worked with some very good and dedicated adjusters. They were, for the most part, always trying to do the right thing and do their job well. However, I always found that they need to be able to support any recommendation for settlement or payment, etc., with something. They need something to be able to do it because they have a supervisor they report to. So they just can't go rogue and start writing checks for any willy-nilly amount. That's not going to necessarily work, and that's not how insurance companies work. So you basically need to give them, that's why we have that word there, give them a reason to pay.
Well, I think it's give them the reason to pay, but not only that, give them a reason to pay, but first call, right? Because at the end of the day, the adjuster is coming in there with a certain amount, right? Most times they'll come in with an amount, and there's sometimes there'll be a situation where you could tell as the mediator, there's more authority there subject to a call, effectively, a call that needs to be made. So I think the question is, how do you, in talking to the insurance representative, what needs to take place for them to make the call? Not just from the information. Is there
I'm going to
anything
use
else?
your analogy and then my own. One, they have to be in the same universe, or I like to say they have to be in the same sandbox. If you're not in the same sandbox, then they're not going to make the call. So the question is, how do you figure out what that sandbox is? And that's what we do during mediation, going back and forth. And maybe they'll tell you, right? And then you go back and say, well, in order for them to make the call, you need to be in this range. Do you want to do that or not? It's not a right or wrong call, right? But that's what they're saying. Because if you're not in anywhere close, then they're not going to make that call. They're just wasting their time.
And I would add to that is it's not just the where they are. I'll go back to the universe galaxy. Are you also the trajectory is now changing. You're basically now converging, and it's clearly evidenced by the insurance rep, that they could make the call because they could see there's a certain trajectory of both parties coming together, right? In other words, parties are moving into the same solar system. There's clearly that direction that's heading there. Because I think that the history of where negotiation has taken place, right? Oftentimes in my mediation, I like to keep track of it visually, of where we are, where we've been, and where we're headed. And I think that sort of sends a loud message of where you've been, where you're at, and the general direction that you're heading, because that will be the signal in its own right for the folks in the insurance room to make that call, to want to make that call, for that matter.
Yeah. And one thing that I just can't overemphasize, we're talking about, going back to the timing of mediation, because all these topics, by the way, are all related, right? Everything in this particular room and in our other room with the policyholder, one is related to the other, impacts the other. They're all really closely tight knit. And the timing of the mediation, I would want folks to try to think about this, because we often get stuck in this analysis. I call this the paradox of certainty. It seems as though sometimes for mediation that you can't make a decision until you have more certainty. You just need more discovery. You need more things. You need more depots. You need more expert reports. You need all that stuff. But certainty is really what trial is for. There you're going to get your result, right? We're going to have a certain judgment that comes down one way or the other. Mediation is a little more flexible than that. And the paradox is, the more certainty that you put into your mediation, it may be harder to actually resolve it, right? You've now invested a heck of a lot more time and legal fees and everything else into this case, not to mention your client is all charged up on either side that we're going to win, we're going to prevail. And now those positions have become entrenched, and it's really hard to make some headway. And then the other way is, well, if it's too soon, then nobody knows what the heck to do, and they don't want to mediate then either. So you still have this, you need to find this fine line of how much certainty do I really, really, really need to try to settle this case at mediation. It can't be complete certainty, because that's a trial, and it can't be at the very beginning when nobody knows anything, because you're not going to make any headway. So it's a fine balance. And this goes for both rooms.
So I think I want to shift over to what's as the mediator as the mediator, the perspective of the mediator. Both rooms sort of are governed by the personalities in them. And why don't we go ahead and switch to that slide? Because I think that it would really help us. We have another poll questions. So please complete the poll. And then we're going to go on to the next slide. And that is the mediator, bringing it together and bridging the gap. So there's lots of personalities in the room, aren't there, Patrick?
Yeah. You've got, and they're interesting dynamics. Whether it's also the personalities between the lawyers and their clients, the adjusters. We've got, I've seen lawyers that are running the show, not the clients, who are the passengers. I've seen the clients, much to the chagrin of the lawyers, who are running the decision against the advice of the lawyer. I've seen adjusters do the same thing in the other room too, right? So you've got to kind of navigate this to figure out, one, who's making the decisions and are they all on the same page? But at the end of the day, I think the personalities can lead to conflict, right? And emotions is the monkey wrench for making good decisions and settling cases. So as a mediator, I spend a lot of time trying not to have people get triggered emotionally. So massaging those personalities and not letting them necessarily come to bear where we start having, a litigious mediation, which actually doesn't exist. That's an oxymoron, right?
A confrontational mediation, I think you mean, right? I've seen it in both ends where attorney, rather than being the objective party, becomes very heated and feels like as though he's been the one that's wronged here. And it's all about zealous advocacy is always part of what being a lawyer is. But I think it's also taking a step back and trying to remember we're here to have a process and also to remember that whether it be attorney or public adjuster, whoever represents the party, I think it's important to keep in mind we're here to the party is there to be represented, but their representation is better served by objectivity and removal of emotions from the equation, especially your own emotions that are part of it. You're here, as a representative, the advisor, as I like to call it. You're there to advise. You're there to not infuse yourself as an additional layer into the mix that compounds the conversation that's taking place. And the same thing goes, by the way, for the insurance representatives. I've seen folks I think it was in recent times, where the insurance representative took it as though you're basically taking his own money and putting it on the table. And I think that it's important to take a step back and remember we're here to have a conversation, and we're here to drive the conversation forward in a very objective way, not let the emotions run high as part of it. But also remember, parties should be involved. We touched on it earlier. Parties should be involved as part of the conversation. That means that the insured should be part of that conversation when the decision is made. He is the decider, ultimately.
And I think maybe an easy way to remember this that brings it all together is going back to the point of setting your intention to make a deal. And if you adopt that mindset going into a mediation versus I'm going to mediation to prove a point, to win a fight, very different than how you would handle I'm going there to make a deal. Right? The things that you say, how you say them, and the things that you do and demonstrate and show is so much different than if you're going to a fight or you're going to trial. So if you keep in your mind when you're going to mediation, my intention is to make a deal, that should keep you in place where you don't let emotions trigger you because they're not helpful. I mean, I read a lot about neuroscience, and there's one really interesting fact that exists out there. And it shows us that motions versus problem solving, they use different parts of our brain, right? They're not the same area. They're different sides of our brain. And also neuroscience demonstrates that we can't do both of those things at the same time. We cannot problem solve and be mad at the same time. It is literally, I guess, biomechanically, however you want to look at it, is
Not
not
possible.
possible. So if we focus on the problem solving, you're never gonna, when you're really focused in that mindset, the emotions, for the most part, should be dampened and shouldn't be coming into play because you're already occupied. You've got that part of your brain triggered, it's on fire, and it's trying to solve a problem. On the opposite end, if you end up getting triggered, neuroscience shows that it takes you 30 minutes, 30 full minutes before you actually come back to where you can start doing things productively. You need to take a time out, literally. Okay. So keep that in mind of where, if you really focus on problem solving, intent to try to, solve the problem, that handles the personalities right there. And as and as mediators, that's what we do. We also try to encourage that, right? Let's focus on how to fix this, right? Those type of things is what we do.
Well, I think part of the problem solving that you're referring to and the fixing, also a great tool that we have here on the screen as part of the negotiation strategy, and as the parties are trying to resolve things, is the brackets, right? Often used in the improper time, but sometimes used just in that right timing, the right moment where that can certainly drive the joint problem solving to the next step, right? Because now you're trying to drive the conversation forward. Any thoughts on when is the right time to use brackets?
That is a matter of personal choice, not only by mediators, but also by the counsel in the rooms. Because at the end of the day, it's their tool. Do they want to start demonstrating a possible range or not? If I had a preference, you say, what would you do? How do you view brackets?
Yeah.
Yeah, I like to use them at the end, towards the end, to see if there is a possibility of making headway. If we've been going back and forth in $2,500 increments and there's still a huge gap, we don't necessarily want to be there for another 6 hours doing that. Maybe at some point the suggestion is made, well, why don't we see if they're going to play in your sandbox? And here, I'm going to create the sandbox with a bracket. Are they willing to go in there or not? And that's kind of how I like to use them.
Do you often find that brackets are met with other brackets?
Yes. And then between brackets, then people go back to their hard numbers, right? But the brackets also demonstrate maybe where you're going, and then that informs the person as to how to use another hard number and back. I always think they help advance. And also they can end a frustrating negotiation if the parties are never going to get close to where they want to be.
So one of a strategy that I think that parties have used in my mediator that I try to get folks to do, especially in the early part, when you have this inflated number on one side, right? And it is a way to demonstrate to the other side, to the insurance, that there is a willingness to move. I think that I call it the Tesla move. You know why I call it the Tesla move? Because have you ever driven a Tesla, Patrick? What happens when you let go of the gas? It's very quick, right? But what happens when you let go of the gas?
It just stops.
You get jolted, right? The reason I call it the Tesla move is you make a major move to try to show that you're advancing the conversation forward, instead of coming in with a major number that everybody knows is not where things are going to ultimately end up if you are well prepared for the mediation. You come in and you make a major reduction, and then hopefully the goal is that the other side sees it. But the other side to that is you let go of the gas. What happens? You're going to get jolted, right? Which means at least you're testing out the other side. You're trying to remove that initial amount that's there, that they see is there, that may not, that signals to them is that there's an amount that is overly inflated in their view. That doesn't mean that it's right, but at least you're signaling to them that you're looking at this objectively. And then you're trying to say, hey, I'm going to start moving much slower if ultimately you're not going to meet me and show me that you're here to talk to me as well. You're here to accelerate and press the gas pedal on your end. Insurance company.
The same applies to the other room. Let's say that you have in the insurance room that any particular adjuster is entrenched on a very low number, let's say.
$500.
We can just pick that one if you want, but let's usually that number doesn't get much larger. Let's pick 5,000 for giggles. Let's say that it's a very low number, and for some reason they just don't want to cover certain things. So you can still use brackets to try to move them. Forget about, let's say that you've done your reasoned approach, right? You've given them your homework and it's not pushing the needle in the other room and they're still stuck. So it's the opposite problem. So they're stuck in a very low number. You can demonstrate at some point, if you don't want to sit there all day long, hey, are you ever going to move or not? Here's a bracket, and it's important information. I know this. Maybe that gets them to finally do something, right? And it's only one way to find out. You ask.
You don't ask, you don't get, right? At the end of the day. So you at least try to drive the conversation forward. Absolutely. Let's talk about, as the negotiation is advancing, do you find that there's a benefit to an adjournment as opposed to an impasse?
Always. You said it yourself. One, information is power. And so long as the parties continue to talk and, even outside of the mediation and continue to exchange information, there's always a chance that they can then resolve the case. And oftentimes they will, even if I adjourn a case, they may settle on their own and never come back to me, which is fantastic, right? Or they've exchanged the information that they need because there's certain things that were missing, direction to pay, whatever that might be, whatever,
an inspection by an engineer that's already pre-scheduled. Let's conduct it and then get back together.
Correct. So an impasse is like, okay, we're done. And that kind of sets you off on a track often where now you're gearing up in the whole litigation world. Whereas this still gives you some sort of pathway and hope that you can still get it done.
And I think that it also, it sends a signal to both parties that there's a want to try to resolve it. When you impasse, the finality is, as you said, like it could send things off in a really bad direction for both parties and sort of the spiral of we're back to the fight, as opposed to we're here talking, let's at least adjourn and reconvene, or adjourn and continue the conversation. But there's one key thing here. We're focused on the fact that we are having a conversation.
Yeah.
And the impasse, in my mind, it truly shuts things down and could truly send things in the wrong direction, where you'll reconvene at a later time in a completely different posture of where you were, and not to the benefit of either party, because at the end of the day, additional dollars have been spent in the meantime.
Well, the impasse suggests that both parties an adjournment suggests that both parties want to do it, right? Because they both have to agree. And then two, very rarely are they just going to sit idly by and do nothing. So they're still doing something, and they're doing something together. So they are in what I call, again, the problem-solving mode, which really is helpful to trying to resolve a case.
When do you think, when there is problem solving and we're getting very, very close to a resolution, do you find that a mediator proposal is appropriate?
Only if they ask me. I'm not one to necessarily interject myself, because I've seen a fair share of complaints where somebody will say, hey, the mediator did this and how dare they? Because we weren't willing to go there. And just by suggesting that number, you've now given credence to the other side, that they feel that that's your evaluation, that's what the case is worth. And therefore now they've just totally broken down our negotiations, and you destroyed it. Like I've literally seen that type of an example being said. So I'm more on the side, if they ask me, hey, both, would you do this? I probably would consider it, but on my own, am I going to volunteer it? I'm not sure.
Would you volunteer the prospects of, in other words, open the conversation? Would you guys be open to a mediator proposal? Not come out outright, but just say, would you agree to a mediator proposal? Would you agree to a mediator proposal? Both say sides are okay with it. Then that number comes in, and say, at that point, it becomes essentially, it's a question of, would you want me to interject myself? Because you could tell that the parties are very close, very, very close, and it's almost coming to a landing.
Yeah, under the right circumstances, probably. But again, it also depends on the personalities. Have you worked with them before? How are they getting along up to this point? I mean, there's a lot of nuances there, and I'm not entirely excited by jumping into the middle of the progress that they made, right? So it depends.
I think if it's, in my opinion, if it does get introduced, it's at the very, 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 very end, when it's you could tell that this thing is going to get resolved. It's just both parties are just sort of, they need the ladder. But you could tell that the best analogy I use is, you as the mediator are sensing that both parties need some kind of a ladder to sort of get them to climb down from, to meet at that number. And it's not about, it's your number or my number, it's the mediator's number in reality. And that allows for a resolution, but it's a really fine and nuanced timing. And I think that what you touched on earlier, you just said the familiarity with the parties, right? And I think that that's a big recipe in using, parties using the same mediators, parties using, always interacting with one another. That all together as a package, you see the type of mediations and how the mediation takes place and how it runs is a completely different way than if all the parties met for the first time with each other, with the mediator. It's a different kind of mediation altogether.
And all the more reason why not anytime soon are we going to have an AI chatbot resolving our cases at mediation. Every time I go to mediation, I see some circumstance like there is no way that could be done. I am sorry.
Well, that could be left for a different future webinar. I certainly think that AI certainly has its pros and cons, and certainly you're leaving us with a lot to think about. As we're wrapping, I think there's one last slide, and you could see it at the very bottom here, and that is the question and answers. But also, I want to open it up to all the audience here that's attended. If you have your own questions, and if you have your own comments and additional thoughts, let's open it up.
Well, we've got two so far. There's from an anonymous attendee. Can public adjusters, DTP companies attend mediations?
That's a good question. Are they authorized to attend? If it's a DTP, right? Are you authorized to attend that mediation? You're not necessarily the party to that mediation. And do you think that would be helpful for them to attend? That's the other question.
And do the parties agree?
Well, do the parties agree, number one?
If you're not a party, if one side doesn't agree, I don't think either of those folks are getting into the mediation, right?
Well, 100%. But I think I want to take it to the next step. Let's just say everybody's in agreement that you could attend. I think that there needs to be some kind of a conversation, an internal conversation on that side that's introducing the additional parties as to who's going to say what, when is the party allowed to interject itself into the conversation, and then what is the purpose? And I think that that's often sort of overlooked. What is the purpose that the party is there? What additional bit is it going to do or add on to the negotiation? And I think that there's some benefit, obviously, that we talked about it earlier, right? The party that's not in the room, I was referring to the direction to pay, where if they are in the room, that could certainly help advance the conversation. But the concern I would have is, are you driving now the conversation? Because you're not necessarily the party. You're not the insured.
Yep. And we have a second question from Mark. From your experience in that room, and I believe this was in referencing the insurance room, how do facts versus a dollar amount matter to an insurer agreeing to pay a fair and equitable amount for a covered claim? And I guess my response to that is it all depends on the adjuster.
Right.
I don't think there is a rule. There are some adjusters that have in their mind a particular number. Maybe they've been ordered to use that particular number and there's no going from that. So additional facts won't matter at all. Versus there are some adjusters that are there that are inquisitive, and actually are trying to figure out to do the analysis, giving them a reason to pay. So they will want to get that, and it may alter. So it actually really depends on the adjuster, the insurance company, how they actually handle their claims.
Well, essentially, do the facts matter, right? And do the facts matter is a function of, are we looking to analyze it? I think that it depends on whether or not there's a willingness and openness, as you said, to reanalyze what's already been analyzed, right? Are we coming into this conversation as the insurance company with the idea that we're willing to reopen the analysis based on the information that's been presented so we can come up with a different conclusion? As you said, it depends on who's there and what's the authority that's been given. Any questions? Any additional questions, thoughts?
Comments? What have you seen?
All right. Well, unless there's anything else,
We do
I
have an
will-
attendee with their hand raised. Hold on.
Oh.
Sharon, I'm going to let you talk if you want
Please.
to
Yeah,
pose your
that'd be great.
question. Sharon Alden.
Hey, Sharon. Pleasure to meet you. You're on mute. You have your hand raised and you are on mute.
All right. So in the meantime, Curtis Hutchins, if you want to go ahead and unmute, you can ask your question.
Hey, Curtis.
Hi. I don't have a question. I don't know why you called on me, but I want to thank the presenters for doing such an excellent job, and I'll see you in Houston.
Right.
Dallas. Make sure it's the right city.
Nice to see you, Curtis.
Dallas.
Where is Wind?
Dallas.
What is January 27th through the 29th or 30th, correct?
Correct. You do have a question in the Q&A.
How are PFS calculated under the new statute, and how critical is it to mediation that we have an expired PFS? For those of you who are wondering what the acronym means, is proposal for settlements. Patrick?
Well, is it critical that it be expired? I guess it's a more powerful argument when it is expired, because now you have some certainty that a certain number has to be met. Otherwise, certain bad things will happen, right? So I guess that, barring that, I mean, I guess if it wasn't expired, some folks would be like, well, that's meaningless until it is. Right. So, okay, great. What are we doing about it today? Because as of today, there is nothing that we can talk about. Fine, it's a warning, but okay.
It's the analysis of the fees. From when did the fees, once it's expired, when did the fees start accruing? And if we're 2 years later on a PFS that's been expired, then that's a completely different thing, as Patrick said, from a perspective of PFS is still pending because it was served about 15 days ago, right? Different thing. Is it different under the new statute? Not that I'm aware of. Are you aware of any change to the PFS statute? I think it's a civil procedure type tool that's not been amended as far as I'm aware of.
And basically, this is your projection, right? You figure out what is it that you think you're going to do at trial, and then subtract the appropriate percentage or add the appropriate percentage to make the other side pay in case that number is not hit. That's all it is.
We have another
Like
question
something
here.
Las Vegas would be good at, right?
We have another question from somebody. Do you think it is appropriate to ask the other side if they are at the mediation to discuss facts or just dollar amount to settle? The purpose would be to find out if we are all in the same sandbox, same universe, same solar system, if you will. You're nodding your head, Patrick.
Yes.
What's your thoughts?
I don't necessarily do that in our joint session, but I always like to have a meeting with the lawyers only. And I will ask that question oftentimes. What are we doing today? What are your expectations? Are we getting into a battle of positions and facts? Or is this going to be more of a numbers thing? And that helps. One, are both sides saying the same thing, or is there a disagreement? That's always interesting to see as a mediator, right? To figure out, are they on the same page or not? And then depending on the answer, then you kind of know how to gauge and move along the process once they give you that information. So I think it's helpful. All about
100%.
expectations.
But I don't know. From my perspective, I always like to ask some questions to give you a hint, at least, because quickly I can pick up on just by having the conversation initially with each party. I can pick up on how each party is viewing it. I don't necessarily like to do it, at least from my perspective, in a joint session, but rather separately in each room. And that, to me, that gives me the tools as the mediator to see how am I steering this in the right path. And it may be, by the way, that each party is sort of, I can help steer the conversation on one side in a one way and the other side in a different way, but ultimately converge on where we need to converge on, which is at the end of the day, a dollar figure where we need to get there. It's just, if one party is absolutely talking numbers and the other one is talking about right and wrong, is it going to be helpful for both parties is it going to be helpful for one party to think that to continue the conversation in the way that they're trying to convince the other side that yes, this is a dollar conversation, and then conversely with the other side trying to convince the other side that it is a factual conversation. You're never going to be able to change either minds. You might as well just continue in parallels, but just try to bring it together and have them converge ultimately on where it needs to be for their own reasons, right?
Mm-hmm. I think in a like say a personal injury setting, that might be more appropriate because maybe some people want to be heard. But mostly in property cases, it is typically about money. But in personal injury cases, that might be more appropriate. People want an apology. They want to be heard. They want to vent. All that's important.
It does happen in the insurance context. I will say, like the insurance wronged me. The insurance didn't pay. I needed the most, and they didn't step up, and all these bad things are now happening. You do get that, but not as often.
Okay, I don't see any more open questions.